Hello, I'm John Cook, Director of the Federal Judicial Center. On behalf of all of us at the Federal Judicial Center, welcome to Federal Trials and Great Debates in U.S. History, Judicial Independence. We're honored and delighted that you're here. Special welcome to the teachers in the audience. You helped shape the future of our society. And to the students, you are the future. And to everyone, thank you for your interest in U.S. history and the important role that the courts play in it. I want to thank a number of people who are responsible for today's program, beginning with our partners at the American Bar Association, and particularly Kathy Hawk, the Associate Director of the Public Education Division there. I want to thank my colleagues at the Federal Judicial Center, Christine Lamberson, the Director of the Federal Judicial History Office, and Associate Historian Jake Kobrick. And of course, the production crew at the center, the wonderful team behind the scenes who are producing this program for us. And then our speakers and faculty, beginning with Professor Tara Leigh Grove from the University of Alabama School of Law, the Honorable Ann Donnelly, U.S. District Judge from the Eastern District of New York, and the Honorable Jeffrey Sutton, Chief Judge of the U.S. Court of Appeals for the Sixth Circuit. We thank them for sharing their time, knowledge, and insights with us. And now I invite you to sit back, relax, enjoy, engage, and learn. Thank you.
Greetings and welcome to the Federal Trials and Great Debates in American History, Judicial Independence. I echo John Cook's welcome and thanks for your participation in this program. I'm Kathy Hawk, Associate Director of the ABA Division for Public Education. Programs like this are critical to helping support the American Bar Association's mission to advance the rule of law and support civic education. We are thrilled to once again be partnering with the Federal Judicial Center's History Office and with Christine Lamberson and her wonderful team. This program mimics the Teachers Institute we do annually for over a decade with the FJC's History Office. As you will see, this program brings together legal historians and federal court judges to investigate and explore important American trials that bleed into ongoing civic debates. For this session, we have broken the discussion into 4 discrete videos. Our first one will be with Professor Tara Leigh Grove providing an overview of judicial independence. We will then be joined again by Professor Grove as she digs into the history of 3 cases that provide various lenses to look at judicial independence throughout American history. For our third session, we are thrilled to be joined by 2 federal court judges, Judge Donnelly and Judge Sutton, who will provide their own unique perspectives on what judicial independence means from the bench. Finally, we will be joined by Christine Lamberson and Jake Kobrick from her office as they investigate how to use primary sources from trials to look at judicial independence in the classroom. As always, we are so thankful for our partnership with the FJC and the History Office, and thankful to you, the educators, for taking your time to investigate these topics and work with us to support student education. Thank you.
Thanks, Kathy. My name is Christine Lamberson. I'm the Director of the History Office at the Federal Judicial Center. Let me join John and Kathy in welcoming all of you and thanking you for joining us for this program. This series, as Kathy mentioned, is part of the FJC and ABA's joint programming promoting the teaching and public understanding of judicial history. You can find written materials to go along with this program on the FJC History website. There you will find historians' summaries and analyses of some of the cases we'll be discussing along with primary sources. You'll also find other cases with similar materials. Now I would like to turn to introducing our guest for today, Professor Tara Leigh Grove. She will be discussing the concept of judicial independence in this session. Professor Grove is the Charles E. Tweedy Jr. Endowed Chairholder in Law at the University of Alabama School of Law. She attended Duke University and Harvard Law School. Before moving into academia, she clerked for Judge Emilio Garza in the U.S. Court of Appeals for the Fifth Circuit. She also spent 4 years as an attorney at the U.S. Department of Justice. Professor Grove's research focuses on the federal judiciary and the constitutional separation of powers, topics about which she has written extensively. Welcome, Professor Grove, and thank you for joining us.
Thank you so much. To get us to think about the concept of judicial independence, I want to take you back to a time from a couple of years ago that I think many of you probably remember. On January 27th, 2017, President Donald Trump issued an executive order that has since often been known as the travel ban. The order suspended the entry of individuals from 7 predominantly Muslim countries. Now, as soon as President Trump issued this travel ban, chaos ensued at airports. It was unclear who could come into the country and who could not. People who were lawful permanent residents or who had been students in the United States were uncertain whether they could enter the country. And soon, a group of plaintiffs, states, localities, and individuals filed suit. And on February 3rd, 2017, just 6 days after President Trump's executive order, a federal district court judge issued a nationwide injunction to stop it. Now, the president did not take kindly to this judicial interference with his executive order. The president called the member of the Article 3 judiciary a, quote, so-called judge, end quote, and described the opinion as, quote, ridiculous, end quote. But as soon as that federal district court judge issued that decision, everything stopped. The chaos at the airports, the stranding of individuals, everything stopped. The Department of Homeland Security complied with that federal court order. With a stroke of a pen, 6 days after an executive order, a single federal district court judge had stopped the most powerful government in the world in its tracks. That is judicial independence. Now, when we think about judicial independence, a lot of folks think about the actual text of the Constitution. Article 3 says that federal judges enjoy their jobs during good behavior and that they cannot have their salaries decreased while they're in office. Now, that's a pretty good deal, right? You get your job ostensibly for life and no one can ever cut your pay. That is in Article 3. But there's a lot more to judicial independence. It's not just about the constitutional text. It's also about norms. Now, I just named one such norm, the norm that federal executive officials comply with federal court orders even when they strongly disagree with them, and even when they think that a federal court judge lacked the power to issue that order. Executive officials still comply. There's actually nothing in the text of the Constitution that says they have to, but executive officials at the federal level and even in states and localities comply with federal court orders today. Many people also say that there's a norm stating that you can't either expand or contract the US Supreme Court in order to influence its future decisions. And even life tenure for federal court judges seems to rely in part on norms. Believe it or not, there was a time in our history when political officials said that you could fire an Article 3 court judge just by getting rid of his job. That is, we're not getting rid of the person, we're just abolishing this section of the federal judiciary, or in the world of academia or the world of education, this department. We're getting rid of the English department. So that was actually done in 1802. It was done in the 1860s, and Congress came very close to doing it again in 1913. But today, it is unthinkable that political actors would fire a federal court judge by abolishing the office of that judge. Today, we just accept that federal court judges keep their jobs unless they are impeached by the House of Representatives and convicted by the Senate. These are all signs of judicial independence. Now, what do I mean when I say judicial independence? Well, there are a couple of different versions that I want you to think about. One is what we might call decisional independence. That is the ability of a judge to issue a decision on the law without worrying about external attacks from somewhere. And there are norms that protect this as well. So even though a judge can be fired through impeachment, there is a very strong norm that political actors will not impeach a judge just because that judge issues a decision that they disagree with, as President Trump disagreed with the decision on the first travel ban. There's also a really strong norm that federal judges will not be personally attacked, that their lives will not be threatened because of their decisions. We don't think about that very much in the United States, but this is not a protection that can be taken for granted throughout the world. And yet in our country, judges can pretty much assume that they will not be physically harmed for their decisions. So those are two extreme examples, but in our system, federal judges also can assume that the judiciary is typically not going to be attacked because of the decision of a particular federal judge or even the decision of the Supreme Court. People might complain about the decision. The decision might get lots and lots of criticism in newspapers or on social media, but the judges themselves know that their jobs and their reputations are secure. So that's decisional independence. There's another kind of independence that I think it's worthwhile thinking about, and that's perceived independence. It's important not only that judges be able to issue decisions without external attacks, but also that people perceive those decisions to be based on law rather than on the judge's political affiliation. And I think there's been some pressure on that kind of independence as well in recent years, as there have been increasing fights over the nomination and confirmation, not only of Supreme Court justices, but of lower court judges as well. People increasingly have a sense, at least those who follow the courts, increasingly have a sense that maybe judges are going to vote as the president who appointed them would want them to, rather than exclusively on the law. Now, I don't claim that most people have that view, nor do I personally have that view, but that's a problem for the federal judiciary as well. To the extent that people think a judge is going to vote because the judge thinks it's ideologically better, rather than based on the law, that's problematic. So we need both decisional independence. We need the judges to be able to feel that they can make decisions without external attacks, but we also need the public to perceive that those decisions are based on law rather than ideology. And both types are really important. And both types of judicial independence depend on norms. And these norms, I want to suggest, are strong today, but also very fragile. So I've mentioned a couple of norms already, including the norm that political actors obey federal court decisions. And one of the things I want to underscore is that's relatively new in our history. For much of our history, political actors thought that they could disobey federal court orders whenever they wanted to. During the Andrew Jackson administration, political officials in Georgia defied Supreme Court decisions and thought, we don't have to listen to what the US Supreme Court says. Even Abraham Lincoln defied a decision by Chief Justice Taney, who was at the time acting as a lower court judge, to release a prisoner in the midst of the Civil War. And there are other types of defiance that are a little more recent. After Brown versus the Board of Education in 1954, which declared that segregated schools were inherently unequal and unconstitutional, public officials set about trying to comply with that decision. And the reality is some public officials refused to comply with that decision. Governor Ross Barnett in Mississippi, Governor Orville Faubus in Arkansas actually went out of their way to defy the Supreme Court's ruling in Brown versus the Board of Education and declare things like segregation forever. Now, by the 1950s and 60s, one might think that that just wouldn't be okay. Even people who were unsure about civil rights might have said, hey, we get that you don't like the Brown versus Board of Education decision. We get that you don't like some of the district court orders that followed it, but you have to comply with them. you have to comply with federal court decisions that you don't like. That is not what happened. So people who supported Brown said you should comply with it, but people who were against Brown said, no, you don't have to. One of the most extraordinary statements that I found in the records of Congress was by Senator James Eastland of Mississippi, talking about Governor Barnett's defiance of the US Supreme Court when Governor Barnett tried to make it very difficult for James Meredith to enter the campus of Ole Miss. Senator James Eastland said, quote, Governor Barnett has courageously and boldly pressed himself forward, both as governor and as an individual, and obstructed an order of a US court, end quote. That is an extraordinary statement to read in the congressional record in the 1960s, and yet that was the view. It was not necessary at the time to comply with federal court decisions that a particular political official did not like. Imagine how much differently the world would have been in 2017 when President Trump issued his travel ban and there was a nationwide injunction against it, if the attitudes had been similar. But they're not. Since the mid-20th century, there has been a growing norm that political officials have to comply with federal court orders. And I have suggested in my own research, that's in large part because of Brown versus the Board of Education and because of the massive resistance against it. Brown was controversial in 1954. It continued to be controversial in much of the country into the 1960s. But today, Brown versus the Board of Education is viewed as canonical, as one of the single most important and valued decisions in US constitutional history. And the massive resistance to Brown is seen as one of the most disgraceful moments in US history. And so, since the 1970s, political officials have not wanted to be equated with the people like Ross Barnett and Orville Faubus, who openly defied the US Supreme Court. Today, there is a strong norm that no one wants to engage in massive resistance against the federal judiciary. Okay, so what do we make of all this history? One of the things I want to underscore for you is that judicial independence is not baked into the constitutional text. It's not baked into our constitutional structure. It depends a lot on norms. Norms that people will obey federal court decisions, norms that people will not attack the federal judiciary, norms that people will trust the federal judiciary to make decisions based on law. But those norms are fragile. They have not existed throughout our history. Judicial independence is inherently a fragile institution that must be preserved and protected. This also tells us a little bit about the Constitution itself. A lot of times when people talk about what is the Constitution, a question I often ask my own students, we think, well, it's this short document that was written in 1787 and ratified by 1789. Well, yes, that's certainly part of it. Other people might say, well, it's not just that text, it's also the way it was understood at the time by the framers and by people at that time. They might say the Constitution or constitutional law also involves Supreme Court precedent and the precedents of other courts. The way we teach constitutional law certainly indicates that judicial decisions are a big deal. But what I want to suggest is that constitutional law depends a lot on norms and conventions and our belief in the system. And I want to end by suggesting that perhaps the most important norm is that we care what the US Constitution says at all.